Let's start streaming. Hello, my name's James. That is my microphone I'm turning down. That's still trying to get used to this. My name's James. I'm currently going to be following for the next hour the first sitting of Parliament after the unlawful prorogation that happened a couple of weeks ago. Currently, the Attorney General Geoffrey Cox is attending to the first batch of urgent questions. Now, there was no schedule for Parliament today, but the urgent questions that are going to be heard was released quite recently. I'm going to change my monitor so you can see this. There we go. Two urgent questions. We're dealing with the first one about prorogation. The second one about Hacker House, I'm not familiar with, and then there's going to be 5 statements. Thomas Cook, Operation Yellowhammer, Iran, update to Parliament, and business statement. So we're currently watching the House of Commons here, and Geoffrey Cox is answering some questions. This is one of the first streams I've done. I don't usually do topical stuff, but then again, here I am. So I've got an updating banner on the right-hand side, which I'm going to be posting updates to as we go on.
Dr. Sarah Wollaston.
Thank you, Mr. Speaker. What message does the Attorney General have for his colleagues in government who have been smearing and undermining Supreme Court judges? Some of this is not done in the heat of the moment. We've been hearing from one journalist that he's been sent copies of articles about Iranian judges comparing Supreme Court judges with them. Is he going to give an unequivocal message to his colleagues that they should resign if they undermine the Supreme Court's independence?
The judges do not exist immune from criticism. There is nothing wrong at all in any member of the public, be a member of Parliament or otherwise, in criticising a court judgment. But what is wrong is that motives of an improper kind should be imputed to any judge in this country. We are defenders of the entire democratic constitution, and we must be sure in everything we say, and I agree with the Honourable Lady if this is what she means, that we do not impute improper motives. With the judgments, we can be robustly critical. With the motives, we cannot.
Jeremy Wright.
Thank you, Mr. Speaker. Is it not important, even in the course of argument on matters as important as these, to remember why we have the constitutional conventions that we do, and that government is entitled, as any other organisation or individual is, to receive legal advice in private? And if it does not, and if those who ask for it to be published get their way, what will happen is that legal advice will become increasingly guarded, increasingly equivocal, and progressively less useful to government in ministerial decision-making. And the consequence of that will be less good legal advice and less good ministerial decision-making.
Well, my right honourable and learned friend has great experience, as does my right honourable and learned friend sitting next to him, of the role which I now have the great privilege to occupy, and he knows how important confidentiality is to the ability of the attorney to give frank, unvarnished advice, sometimes unwelcome advice, to those who are conducting the policy of the government. So he's quite right. And he discharged his functions, as did my right honourable friend for Beaconsfield, with great distinction. And I'm proud to have been a successor of that.
Angela Eagle.
Mr. Speaker, the Right Honourable and Learned Gentleman has made it quite clear that the judges in the Supreme Court had every right to come to the decision they came to, and in fact they came to it unanimously in an excoriating judgment which should put the government's front bench to shame. What is his view, therefore, of a leader of the House who persists in believing and makes it known that he feels the Supreme Court have instituted a constitution
expressing robust, critical views about a judgment. insofar as it imputes inappropriate or improper motive, then it is wrong. So I think it's a question of wording and of being careful with one's language. But I took that remark, insofar as I saw it reported, simply to be a robust criticism of the judgment and nothing more, which is entitled.
Sir Oliver Letwin.
Thank you, Mr. Speaker. Mr. Speaker, I have absolute respect for the integrity and the competence of the Attorney General. In the light of what he has told the House this morning, can he guarantee absolutely that, save potentially a few days before a Queen's speech, there can be no question of his permitting Her Majesty's government to have a prorogation between now and the time of 31st October of this year?
What I can undertake to my right honourable friend is that there will be no prorogation that doesn't comply with the terms of the judgment of the Supreme Court.
Migilia.
Mr. Speaker, the Attorney General said that he's going to review whether advice should be published, but in answer to the former Attorney General, he upheld and defended the privacy of that legal advice. So can he tell the House the scope of the review he's undertaking? Is it just when the government is defeated in the Supreme Court, or will it be drawn more widely?
Well, what I'm considering is the public interest and whether or not there are factors in this case connected closely with the public interest generally that should outweigh the Law Officers Convention and lead to disclosure. But that isn't only my decision. I'm in the position in a rough and approximate way between a lawyer and his client. And I must ensure that there's proper consultation, proper reflection on what the public interest requires. And that I have undertaken to the Right Honourable Lady who asked the urgent question to do.
While he's just spewing this out, interesting point they just made, he won't rule out another prorogation.
Sir Christopher Choate.
Just an unlawful one.
Mr. Speaker, did it come as a surprise to my right honourable and learned friend that the Supreme Court ruled that the act of prorogation is not a proceeding in Parliament? And if that is the new law to which my right honourable friend has referred, would it be open to this Parliament to change the law back to what we thought it was before?
It's a good question.
It was a surprise, my honourable friend asked me.
Yes.
Quite a lot about the judgment came as a surprise.
Yes.
But that particular part proceeded from a quite strict or narrow interpretation of the Bill of Rights and what was a proceeding, and it was interpreted to apply the protection afforded by the Bill of Rights to the core and essential business of Parliament. And it was held, as my honourable friend will know, by the Supreme Court that such a proceeding, namely the execution of the Queen's Commission in the Lords in the presence of Mr. Speaker and those who attended that proceeding, was not sufficiently close to its core and essential business to attract the protection of the bill. It would of course be open to this House to decide to legislate otherwise, and no doubt that's one of the implications of this judgment that will have to be reflected upon in the coming months and years. I know that there was a widespread view that it was indeed a proceeding in Parliament, but the Supreme Court is as entitled to redefine, or at least to take a view of its definition of the protection afforded by the Bill of Rights, as it is to invent a new legal principle, as it did in this judgment.
Legal principle.
Mr. Speaker, I'm sure many of us would like to congratulate the Honourable Learned Member for Edinburgh South West and Gina Miller for making sure that this remains a sovereign Parliament.
Now, this lady was actually part of the Conservative Party until recently.
Which he hasn't answered. She asked him whether he could confirm that the Cabinet, or members of the Cabinet, and he's a member of that Cabinet, had asked to see his advice, but they were denied that opportunity. Can he confirm that his advice was requested by fellow members of the Cabinet, but it was denied.
Well, let me make plain that I have never denied any member of the cabinet any sight of any advice of mine. I am not certain who and when else asked for that advice, but I certainly have never denied it.
Rory Stewart.
Mr. Speaker, Right Honourable and Learned Friend agree that rather than being some newfangled, innovative decision, this was a profoundly conservative decision by the Supreme Court asserting the ancient sovereignty of Parliament, and that fundamentally the principle at stake here is that, of course, neither that court nor any other court should determine whether Brexit takes place. That decision has been made by the people. But it is for this House, the only directly elected representatives of the people, to determine the form in which that Brexit happens.
Let me say to my right honourable friend, the Supreme Court invoked the principle of parliamentary sovereignty and the the Convention of Parliamentary Accountability, ministerial accountability to Parliament, as a justification for making justiciable the decision to prorogue, and that's what it was entitled to do, and it effectively amounts to converting a political convention into a legal rule. That traditionally was not thought to be possible. The Supreme Court has decided that it is, and I certainly do not in any way complain with its right to do so. But what I would say to
Rory Stewart, by the way, another one that used to be Conservative.
I would agree with him that Parliament has to determine the terms on which we leave. But this Parliament has declined 3 times to pass a withdrawal act with which the opposition, in relation to the withdrawal act, had absolutely no objection. It was then we now have a wide number of this House setting its face against leaving at all. And when this government draws the only logical inference from that position, which is that it must leave therefore without any deal at all, it still sets its face, denying the electorate.
He's having a go at Parliament now, that they can't make a decision.
Its say in how this matter should be resolved. This Parliament is a dead Parliament. It should no longer sit. It has no moral right to sit on these green benches, and whatever.
Yeah, they always get rowdy like this. Very, very common. He's having a...
The House must come to order. We've got a lot of business to transact.
We do have a lot.
Further urgent questions. There are no fewer, I say, for the benefit of those observing, 5 ministerial statements.
Yes.
The attorney must be heard, and so I hope will lots of other people. The attorney.
They don't like to hear it, Mr. Speaker. They don't like the...
They don't like it, Upham.
Twice they have been asked to let the electorate decide upon whether they should continue to sit in their seats, while they block 17.4 million people's votes. This Parliament is a disgrace. Given the opportunity, since I am asked, let me tell them the truth. They could vote no confidence at any time, but they're too cowardly. They could agree to a motion to allow...
What's he doing? He's all over the place.
Too cowardly.
Holy shite. Seriously.
This Parliament should have the courage to face the electorate. But it won't. It won't, because so many of them are really all about preventing us leaving the European Union at all. But the time is coming. The time is coming, Mr. Speaker, when even these turkeys won't be able to prevent Christmas.
What is he doing? That is bizarre. The Attorney General Geoffrey Cox, I think he's a wannabe next Prime Minister, although I shouldn't really be having opinions.
David Hanson!
Thank you, Mr.
Deary
Speaker.
me.
I think the Attorney General will find that the moral right I have to sit in this House is due to an election called by the Honourable Lady for Maidenhead, which she lost 40 seats in.
Well, of course, if someone else is
And I
so
will
worked up,
represent my constituents as long as
they
I
work
sit
up
in
other
this
people.
House, and I'm here elected by the people to do so. Could he tell this House how much taxpayers' money has he spent in closing down our voice?
All I'm suggesting to the honourable gentleman is that he gives his constituents the chance of electing him again.
Order! 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 I say to the honourable gentleman, the member for Kingston upon Hull East, that as a result of my prodigious efforts last week, audiences in New York, Boston and Zurich are now aware of the honourable gentleman as the noisiest member of the House. I always enjoy listening to the honourable gentleman, but preferably when he's on his feet rather than in his seat. The Attorney General.
If the honourable gentleman is so confident that his electorate will consider that his moral right to sit here is so strong, why doesn't he submit it to them now? All we need, I offer this to the front bench of the Labour Party, all we need is a one-line bill that we could put through with the Speaker's help, fixing the date of the general election by a simple majority, and we could have the election. Why doesn't he tell his front bench to put his confidence in his constituents to the test?
Mr. Ian Duncan Smith.
Mr. Speaker, I wonder if my right honourable learned friend, having read the full summary of the judgment made yesterday by the Supreme Court, was also struck by something that seemed to be missing within their methodology. That when they stood up, they said, for the right of Parliament to hold any executive to account, at no point in there did they reference one of the ways, of course, of avoiding prorogation or dismissing it would have been to have had a vote of confidence in the government or to have voted for a general election. Does he not agree with me that that would have been the surefire way of the opposition parties to have secured an end to any prorogation and an immediate change of government if so wished, but they were frightened?
Yes, I entirely agree with my right honourable friend. In our constitution, when a government can no longer govern because the Parliament has withdrawn its assent, the moral and constitutional thing to do is have the courage of your convictions, which this spineless gang on the front bench here do not, to place a motion of no confidence before the House. But they haven't got the guts to put that motion of no confidence because most of them don't want their own leader in power.
Carol Monaghan.
Mr. Speaker, now, maybe say first of all to the Attorney General that none of us on these benches are worried about a general election.
Referencing Labour's chickening out.
The right honourable member
Is it, actually? I'm not sure.
has suggested that the unanimous verdict of the Supreme Court was the equivalent of the view of just a few academics, and the Leader of the House has described the verdict as a constitutional coup. Now, unfortunately, these views do gain traction amongst members of the public. So will the Attorney General take this opportunity to give a strong statement of support both for the judgment of the Supreme Court and for the importance of the independence of the judiciary?
That's worth nothing. So I'm just going to show you the schedule coming up very soon. We are going to have a urgent question by Lingla Morrison about Boris Johnson's payments to a friend's company. And then we've got some statements. Secretary of Transport, is that? Secretary of State for Transport, talking about Thomas Cook, which recently fell down. Michael Gove talking about Operation Yellowhammer. The document that got released about the effects that Brexit would have, and then Dominic Raab on Iran. Not sure about that one, but he is First Secretary of State, Foreign Secretary even.
Is right, Mr. Speaker. We had notice of the
listen to this.
intention to prorogue. With your assistance, we could have entertained motions against it, or even a motion of no confidence. So it was a coup, wasn't it?
Well, I know that my right honourable friend will know that I want to be, if I can, and when it comes to the judges, though not to this shower, but when it comes to the judges, I want to be respectful and careful. And it is important that we should understand that these judges are protectors of all our freedoms and all our rights.
Order! I don't normally offer stylistic advice to the Attorney General.
Okay, he's going to do
but
his thing. Actually, they've actually posted a photo schedule, which is very, very useful. Statement from the Prime Minister is expected at 4 p.m. Oh, that's long after I finish this. And then a business statement at 5 p.m. A business of the House, I expect that to be.
Lessons to front benchers. It could be our beginnings of a new and very glorious, or even more glorious, career.
He's posturing some more.
I've now lost my thread entirely.
Yes, no kidding.
They say they want me to sit down, so I'm going to. We'll gratify the opposition.
Mr. Barry Sherman.
Mr. Speaker, I came into the chamber today thinking I felt sorry for the Attorney General. But as he started, I did. Fair enough. But every word he has uttered, no shame today, no shame at all. The fact that this government cynically manipulated the prorogation to shut down this House.
Very angry people.
As a democratic assembly, he knows that that is the truth. And to come here with these barristers' bluster to obfuscate the truth, and for a man like him, a party like this, and a leader like this Prime Minister, to talk about morals and morality.
This is going in the 6 o'clock news. Now it's going in the 6 o'clock news. Holy bejesus. Barry Sherman, Labour and Cooperative, Huddersfield, that was.
In that marshmallow of the rhetoric, any actual question.
Yeah.
But insofar there was a question.
This is why you don't shout your questions.
If the honourable gentleman thinks that the government should no longer be governing, tell his leader to bring a motion of no confidence this afternoon. Tell his leader to agree to a simple one-line statute that fixes the election by a simple majority. And we would be delighted to meet him wherever he chooses, in front of the electorate. Who will judge whether the machinations which he supports and the devices he resorts to in order to make sure this dead Parliament continues are right or wrong?
Antoinette Sandbach.
Thank you, Mr. Speaker. The Attorney General speaks of moral and constitutional courage. Can he explain to this House why the government didn't have the moral and constitutional courage to file a witness statement in the Supreme Court attesting to the truth of the position that was being outlined to the Supreme Court judges?
Yeah, so there was only one letter sent to the Supreme Court during their ruling by the defendant.
I can't, I'm afraid, make comments on matters that are plainly covered not only by the convention but by legal professional privilege. But what I would say to my honourable friend is that the government's position was set out very clearly in argument, and if she follows it all, it went on for a very long time, and the Supreme Court decided against it. We accept that position.
Mr. Nicholas Edward Coleridge-Bowles.
Thank you, Mr. Speaker. Having lost in court, the Attorney General is keen to try his hand at another test of an election, and maybe I can help him. In paragraph 41 of their unanimous judgment, the Supreme Court referred to 2 fundamental principles of our constitutional law, and I quote, The first is the principle of parliamentary sovereignty, that laws enacted by the Crown in Parliament are the supreme form of law in our legal system, with which everyone, including the government, must comply. And that is the end of the quote. Can the Attorney General confirm that he and the government will comply with the law known as the Ben Act, recently passed by this Parliament, that has received royal assent?
Yes.
That was a simple one. Saw that one coming.
Steve Baker.
Speaker, isn't it the case that, contrary to the shouted opinions of the front bench opposite, what the Supreme Court has done is to invent a new constitutional rule, just as Lord Sumption told us on the Today programme this morning, and Lord Sumption also said that this was a revolution. He described the decision as revolutionary. So isn't it the case that prior... She shouts shocking, it's Lord Sumption who said it.
Yes.
Isn't it the case that prior to this revolutionary decision by the Supreme Court, it's quite likely, indeed probable, that his advice was entirely correct until the Supreme Court changed the law?
I'm very grateful to my honourable friend for the question. I can't disclose what advice I gave. The honourable lady
going to make a thing
who
about
first
it.
asked this question had that answer, and I'm afraid I'm going to have to keep giving it today. But what I would say is that the Supreme Court did indeed, as it overtly and explicitly said, develop the law. It took what was a political convention, hitherto in all of the constitutional textbooks described as unenforceable by a court, and decided that it would set a test and convert it into a legal principle and a legal test. And that it was perfectly entitled to do, just as this House will in the coming months and years have to reflect upon the implications of it and whether it is content to leave that position untouched.
He likes closing his
but for the
notebook quite a lot.
moment, it is the law, and the law must be obeyed.
Stephen Doughty.
Oh, I heard Joe there.
Mr. Speaker, can the Attorney General be very, very clear? Were the Director of Legislative Affairs, Nicky Da Costa, and the Cabinet Secretary, and indeed any other advisor, including the Leader of the House's office, asked to make sworn statements in these cases, and did they refuse to do so, and if so, why?
I simply cannot comment on matters that pertain to the internal preparations of cases which are covered by legal professional privilege. It's simply not reasonable to ask them to do so, particularly when it relates to individuals. So the honourable gentleman should make no assumptions one way or the other from what I'm saying. The fact is they're covered by privilege and they must be respected.
Vicky Ford.
Many
Joe is mouthy.
and experienced lawyers
Labour Joe.
Some of us are not lawyers, and many of our constituents are not lawyers. So could my right honourable friend,
Oh,
the
you look
Attorney
familiar.
General, explain this very clearly? Is this a new law? Does it set a new precedent? And if it is a new law and a new precedent, will the government comply with the new law and comply with the new
Yes,
precedent?
he will always say the government will.
What it is a new principle of law which has been found to exist by the Supreme Court, and where hitherto it has not been thought that a court could go. But that is, the court is entitled to develop the common law, and that it has done. It does set a precedent, it is binding, unless this House, in due course, should consider it should take action to alter that position.
Caroline Lucas.
Thank you, Mr. Speaker. While yesterday's Supreme Court decision was extremely welcome, upholding parliamentary sovereignty, it should never have come to this. Our centuries-old unwritten constitution, based on gentlemen's agreements, is not fit for purpose when dangerous populists are in office. Will he therefore consider urgent proposals for a written constitution developed with real citizens' engagement, since our democracy belongs to all of us, not just those who think they're above the law.
Well, I have to say I have a degree of sympathy with what the Honourable Lady says. I do think that as we depart the European Union, there is ground for thinking again about our constitutional arrangements, how they should be ordered. And in doing so, I think a widespread public consultation of the kind she's describing would be essential. Because any new constitutional arrangements would have to be sanctioned by the widest possible public support and assent. So I do have some sympathy, and no doubt over the coming months and years, this will be a subject of important concern to this House.
Dr. Julian Lewis.
Given that
Why is
three
Paddington
of
Station
the most
trending?
distinguished lawyers in the country,
Although this is very
including
interesting,
the
I'm
Master
seeing,
of the Rolls and the
seeing
Lord
this.
Chief
If I just close
Justice,
down my password
found
thing.
in the lower court that the government's case was entirely correct, can the Attorney General enlighten puzzled non-lawyers like me as to why not even one out of 11 Supreme Court judges could be found to agree with them?
Don't know why that might be, but
Honourable
oh,
friend
it's
is
a
asking me to
sponsored
look
thing, I think.
there into a crystal ball. Far be it from me to fathom the inscrutable minds of their lordships in the Supreme Court as to why they chose not to dissent if they were minded to dissent, or to agree if they were minded not to agree.
Chris Bryant.
Thank you, Mr. Speaker. I, for one, am delighted that we are sitting. But the Attorney General is absolutely right about one thing. The result of yesterday's ruling is that all future prorogations will be justiciable by the courts. The only answer to that, frankly, is legislation by this House. My gentle suggestion is that it might be a good idea if prorogation in the future were only allowed to proceed if there had been a vote in this House in favour of it.
Well, that is obvious, if I may say to the Honourable Gentleman, that is as I would expect from him, particularly in his new guise as an aspirant to even higher office, constructive, helpful, impartial, and a model to us all.
That's cool. I think, but I'm not sure, that the Attorney General is seeking to help the Honourable Gentleman.
Charlie Elphick.
Mr. Speaker, can I ask the Attorney General that in applying this new legal principle that has been created or invented by the Supreme Court, how many prorogations in the last century would have passed muster to the test that has been created? How can this longest session that this House has had since the Civil War now be lawfully brought to an end, and a Queen's speech lawfully brought forward? And finally, is royal assent a proceeding in Parliament?
No, it's not. We've already answered that.
As to my honourable friend's first question, plainly, if one re-examines the historical records, there is no doubt that there would have been some, possibly quite a few prorogations that under this test might have had difficulty in passing. For example, Ramsay MacDonald prorogued this Parliament in 1930 for some months during the course of a minority government, at a time when the Great Wall Street crash had happened in 1929, and when I've no doubt that some would say the House should have sat to determine the onset of the Great Depression and to debate those important matters. But the courts looked on. They looked on impassively as that Labour government decided to prorogue.
Attacking
and
Labour
again
again.
in 1948 and right up into the 1990s, when it was said that a parliament had been prorogued in order to avoid an embarrassing select committee inquiry. And from now on, when a Prime Minister has to prorogue Parliament, he'll have to look at all the select committees and see what inquiries they're doing,
He's
and which
doing
chairman
plenty.
of which select committee might say, in a mortally wounded and offended manner, why to prorogue and not to allow my select committee to report is a matter of public importance, which I'll go to court and stop the prorogation for. So I do think that this test set by the Supreme Court invites quite a number of significant questions. I do.
Luciana Berger.
He's not really answering for the government.
The Attorney General has told us that he doesn't agree with the judgment and that he argued against it. If that is the case, and the Attorney General was so convinced that prorogation was lawful, why didn't he and the government provide a witness statement to the Supreme Court to make that case?
We've already asked that.
Look,
Calm.
there are all
Comment.
kinds of reasons why in judicial reviews witness statements are not given in cases of this kind. And I cannot discuss
There we go.
the internal counsels of the preparations of a legal case
Can't do it.
because it is covered by an wholly appropriate, I'm sure she understands, legal professional privilege.
Exactly.
Stevenson.
Given that Parliament is at the apex of our constitutional system, does the Attorney General believe that the appointment of Supreme Court judges should receive the formal approval of Parliament?
I understand the question of my honourable friend, and I say to him quite frankly, I think that that is a matter which this House in the coming months and years may need to reflect upon, depending upon how the constitutional arrangements of the Honourable Lady for Brighton, forgive me, Brighton and Hove, but Brighton Pavilion, indicated. Because I do think that we are going to have to look again at our constitutional arrangements. And we should see if we could find some common ground on that. I mean, we need to have a proper consideration of it. As we leave the European Union, a great gap opens up from where we take away from legal integration all of this European Union law, and we need to think about the implications of that. So I agree that one matter may very well be whether there will need to be parliamentary scrutiny of judicial appointments in some manner. I have to say that I'm not enthusiastic about it, but I understand why my honourable friend asked.
McFadden.
The Attorney's defence today with regard to the Supreme Court judgment appears to be that because the government won the semi-final, they should have been awarded the trophy. That is not how it works. And in the final, he should acknowledge that the government lost 11-0. With regard to his call, which repeats the call from the Prime Minister, for the public to break the Brexit deadlock by casting their votes. If he's so keen for a public vote on Brexit, why does he not offer the public the chance to vote on the final government Brexit deal, however that turns out?
Because I'll tell him why. Because I think it would be an insult to the millions who voted in the first to have a second one before we'd implemented the first. Secondly,
I'm pretty sure these questions have been asked a million times. Do you support the initial referendum? Do you want a second referendum? Do you want to... It's all the same stuff.
the question now of this...
We're still on the first urgent question, by the way. This is the urgent question about the prorogation, which Geoffrey Cox, the Attorney General, is answering for us now.
It's morally correct.
We do appear to be going around in circles a bit, though.
Have an election. What I object to here is that this party and this side of the House has repeatedly sought to block that and to prevent the electorate from having its say when this Parliament is as dead can be.
Third comment he's made about dead Parliament.
Mr. Speaker, and following on from that, would the Attorney General accept that the vast majority of people I talk to have great faith in this government, but they have no faith in this Remain Parliament? And whilst there are important legal implications for yesterday's ruling, the practical implications of that ruling is that this Remain Parliament that has talked about Brexit for over 3.5 years will now get several more weeks to do what they possibly can to talk about Brexit but make absolutely certain that 17.4 million people never get what they voted for.
He's made his own point in his own way.
I wholly understand the strength of feeling of my honourable friend, and I agree with almost all of it.
Catherine McKenna.
Thank you, Mr. Speaker. The Attorney General accepts that his legal advice was wrong, that the government got this wrong. Whether in law or not, it was patently obvious to everybody watching that it was wrong to prorogue Parliament in that way. The United Kingdom head of state was asked by the Prime Minister to agree to an illegal course of action based on incorrect advice. What does he believe should be the consequences for those responsible?
The same consequences that flow from any good faith implementation of advice that at the time is perfectly respectable and tenable advice, as this was. The fact of the matter is that the government's position was that the prorogation was lawful and it was constitutional. Now that was the advice that the government had. It was the advice that it gave to those who asked it, and the Supreme Court has decided we're wrong. We accept that, as I've been asked. And respectable point of view.
Dr. Caroline Johnson.
Thank you, Mr. Speaker. My constituents in Sleaford and North Wycombe voted
Speak
to
up.
leave the European Union, and many of them have written to me since yesterday's judgment concerned about whether that will be delivered. Can my right honourable friend, the Attorney General, confirm there is nothing in this judgment that will prevent us from leaving the EU on the 31st of October, as they voted for in the referendum?
No, I can tell you that myself.
There is nothing in this judgment that applies directly to the question of our departure to the European Union. So, as the justices made clear, this was a decision solely on the lawfulness of the prorogation.
Mr. Speaker, further to the question by my honourable friend, the member for Grantham and Stamford, has the government been seeking a route not to comply with the Ben Act, as several ministers have made clear, and has he been asked to offer legal advice to that effect?
Ben Act is to ask for an extension.
I can't answer the last question, as he well knows. As Attorneys General, have long maintained the Convention, we cannot disclose either the fact or content of any advice. But I will deal with the first point. There's no question of this government not obeying the law. There is a question as to precisely what obligations the law might require of the government, but once those obligations are ascertained with clarity, and I'm not saying that they aren't clear, I'm just saying that it's a legitimate consideration the government must go through, the government will obey them.
Yes.
Mr. Speaker, set alongside the decision of the Supreme Court, what force in law does the decision of the British people to leave the European Union have?
What? What? Don't understand that one.
The law in relation to the referendum is that it was not binding upon this parliament.
Right, yeah, because it was just a referendum.
It was
right.
binding in every moral sense upon those who promised the British people
Morally
that
binding.
it would be implemented, but it was not binding as a matter of law.
Deirdre Brock.
The Attorney General excuses recent comments by members of this House as simply the expression of robust critical views. But wouldn't you agree that, in fact, those who were arguing recently that Brexit would give back control to the UK courts and the UK Parliament have now completely U-turned and are actively working to undermine those institutions?
No, I think that's a ridiculous assertion, in fact. I mean, the reality is that what we who believe in leaving the European Union have fought so long for is to return to the United Kingdom the power to chart its own course, ungoverned by unelected or other institutions in the European Union. Now, how we arrange our constitutional arrangements is a matter for us, and it should be a matter for us. It should be a matter for the democratic assent of all the peoples of the United Kingdom.
I tell you what, this isn't going to help the Brexit fatigue that I'm definitely currently feeling.
This government or this side of the House is trying in any way to avoid that. What we're trying to do is make sure those powers come back to the British people where they should reside.
Andrew Bridgen.
Thank you, Mr. Speaker. Does my right honourable and learned friend agree with me that, contrary to the repeated claims of the Prime Minister's many political opponents, that the moment he announced prorogation he broke the law, the fact is he did not? Because, as we all know now, the Supreme Court judgment yesterday set new law.
That's an interesting argument. It wasn't unlawful because the court didn't say so before.
The Supreme Court judgment said that the government got the law wrong. We have to accept that, but it is perfectly true that in doing so, they effectively invented or created a new legal principle, which hitherto had been a political convention, and defined that principle in a new legal test. It's a crystal ball gazing to know whether any court would decide to do that. It did, though the court below, led by the Lord Chief Justice, concluded that it should not.
Ian Murray.
Thank you, Mr. Speaker. During the Attorney General's theatrical rant earlier,
yes,
he inadvertently forgot to answer the question from my right honourable friend, the member for Devon. How much has this prorogation cost the taxpayer, and all the legal advice and all the legal consequences cost the UK taxpayer?
Answer. I don't know is the answer to that question, but I'm sure if the honourable gentleman wants to know, he can put down a written question, or I'm happy to write to him if you like. I'm very happy to disclose that in due course once the costs are known. But I may say to the honourable gentleman, all those costs could have been saved if he just voted for an election. We could have avoided these cascades of cash falling upon so many lawyers in so many jurisdictions by the simple act of him having the moral guts and not being chicken, which is what they are.
Back to the chicken argument.
On the subject of taxation, could my right honourable and learned friend advise me? These legal actions, I believe, have been part funded by crowdfunding. Will that funding be taxable, and will the tax payable on that crowdfunding have to be paid by the individuals bringing the cases?
I don't believe they're taxable, but I have to say to my right honourable and learned friend that I would need to, if she would permit me to look into it, and if she wishes, I'll certainly write to her on the subject.
Helen Goodman.
Speaker, earlier this morning, the Attorney General set out again his long-held views about why publishing his advice is not a good idea.
Yes.
So has he requested a leak inquiry to discover who gave documents to Sky News last night? And if he hasn't, is that because he's worried it'll unmask machinations in Number 10?
Sky News' documents?
They aren't just my long-standing views, as I know the honourable lady will accept. They are the long-standing views of successive attorneys of all governments over many, many years. As to the second question she asks, I am not aware whether there is or isn't a leak inquiry, but these days I'm so used to the porousness of government that frankly I use Cabinet these days to advertise whenever I need to some particular cause that I want to espouse. The reality is that this government, this Parliament, is in a position where we need to go to the electorate, and I would urge her to support that as soon as possible, because it is the only morally right thing to do, to subject these debates to the public again.
Don't see any leaked documents anywhere.
Mr. Speaker, I must raise my concerns about the Attorney General constantly saying that this Parliament is dead. This Parliament was elected in 2017. It reflects the divisions in this country, the divisions in our communities, and the divisions in our families.
It's not what he's talking about.
The failure is that we have not yet reached a compromise.
Yes.
Many of us long to leave the European Union, as we set out in the referendum, but are frustrated by the fact that we have not been able to find a consensus amongst the different factions. Can I urge the Attorney General to work with colleagues to try and find that compromise and to cease this language of pitting Parliament against the people?
Right.
I assure my right honourable friend that if I hadn't been driven to this language, I would never have used it. The fact is... Oh, yes.
Uh-huh.
Oh, yes.
Not sure if that's a good argument.
The fact of the matter is that the opposition won't let the government govern. The opposition won't do what the opposition should do in these circumstances, which is vote for an election. By any standards, the government is in a minority. It's having the order paper taken over from it again and again, and no doubt further attempts to come.
Here we go.
And that is the very definition of a parliament that won't...
Alright, let's turn that down for a second. PM was advised by Attorney General suspension was lawful, so here are the documents that got leaked apparently. It is not in full. Yeah, so that would be a leak, wouldn't it? The redacted version of the document obtained by Sky News. Yeah, it was clear that the timetable would not conflict with statutory responsibilities. Okay. Taylor said that his advice on the question of law said it was lawful and within the Constitution, and any accusations of unlawfulness or constitutional outrage were motivated by political considerations. The proposal was compatible with the provisions of the NIEF Act 2019. But what that doesn't say is that the decision that it was unlawful because of the political reasons behind the prorogation. But what that leaked document says is it's lawful. It's unlawful if it were motivated by political considerations, which was correct, and which is why it was made unlawful.
Offering legal advice in such challenging circumstances. In view of the fact that his advice on prorogation has been found to be unlawful and building on questions previously, can he answer to the House whether he has been asked by the Prime Minister to proffer advice on the legality and whether it would be lawful to ignore the instruction of the Benn Act? Whether he is offered advice or not is not subject to privilege.
Words fail me, Mr. Speaker. They really do. The right honourable gentleman arises in the full force of his morality, having been elected for one party and sitting there for another.
Stop attacking people. Just answer questions, please. It makes my job easier.
The chicken run, the rat run before him, having said already that she thinks there should be a by-election.
Jeffrey Cox is very theoretical if you haven't quite gotten that yet.
And suggest somehow that I should have affected greater humility. I think he should be on his knees to his own constituents. On his knees to his own constituents, begging their forgiveness for his betrayal. The fact of the matter is, the question is subject to the Law Officers' Convention, as he knows, and I cannot answer him. But I would suggest that when he's back here re-elected by his constituents, as no doubt he has a confidence that he will be, ask me then, and maybe I'll give him an answer outside.
Are we done with you? Are we done with
Mr. Speaker,
no?
does my right honourable and learned friend agree with me that if Her Majesty's government chooses to push its prerogative powers to the limit, as indeed it is quite entitled to do, if perhaps not necessarily well advised to do, that it should both expect the challenge that it has had and perhaps the conclusion that's arisen from that?
I didn't hear a word of that. I'm very sorry, and I'd be most grateful.
They're very unattractive. Yeah, there was a very unattractive rant fest taking place between
that's what that noise was.
members on opposite sides. the House, each gesticulating aggressively at each other. It's a very undesirable state of affairs. Let's have a bit of calm. Let's have the question again.
We might have a little punchy in the House. We are seeing much anger in the House at the moment.
Hear me again, Mr. Speaker. It's not normally you're most generous, but would my right honourable and learned friend agree with me that if Her Majesty's government wishes to push its prerogative powers to the very limits, which it is quite entitled to do, if perhaps not always well advised.
So for the quality drop, by the way.
The kind of consequences we've seen in the last few days are inevitable.
I think that in any situation where constitutional powers are pushed to their limits, it's bound to cause strain. And I completely accept that we are in an unprecedented time now when constitutional limits are being pressed on all sides. In this House, by seizing control of order papers, by rejecting the opportunity for elections when they won't let the government govern. These are factors that place huge strain upon our constitutional arrangements. And I agree with him.
He's just spouting the truth at the moment. I just want to show you this. It says here, this chap who's speaking on BBC Politics Live, the lunchtime programme, he's saying that there's about 250 colleagues who are not present in the House of Commons, him being one of them, of course, being on the news programme. But yes, he says that it should be standing room only, and it's not.
Members are standing to contribute who were not standing at the start of the statement. That of itself is perfectly reasonable, and I will seek to accommodate them if a thought has occurred to them that they want to convey, or the question that they want to put would otherwise go unasked. But once those who are standing have asked their questions pithily, we must move on to the next urgent question. Clive Efford.
Yes. Mr. Speaker, the Attorney General has really tried to take the high moral ground on this, but I have to wonder what morals were applied by the government that led to yesterday's Supreme Court decision. So can he tell the House, when was it that he first became aware that the advice that was given to Her Majesty the Queen, to the Speaker of this House, and this House itself, about the reasons for prorogation, and that those reasons were not true?
That, if I may say so, is what we used to call in advocacy terms a "when did you stop beating your wife" question. The reality is I don't accept the premise of the question. There is no question that the Supreme Court found in any way that any advice that had been given that was consciously or knowing misleading.
Whittingdale. Would my right friend agree that there is a judgment which is superior to that of any courts? And that is the judgment of the British people, which has once been given on the question of whether or not this country should remain a member of the European Union, but has twice been prevented from being expressed in a vote of this House. And is it not now time that we should allow them to give their judgment on this Parliament?
Mr. Speaker, I couldn't agree with more than my right honourable friend. The time has come. The fact is, this Parliament has no further point. There's no possibility of us governing while this Parliament continues to block everything it does.
Brevity now required. Single sentence questions, please, without preamble. Lady Herman.
Much indeed, Mr. Speaker. I've listened very carefully to the Attorney General. Haven't agreed with a fraction
Here's a preamble.
of what he said. But I would like the Attorney General to answer a specific question. Did it never cross his mind that if the Prime Minister made a ridiculous decision to prorogue Parliament for 5 weeks in the run-up to Brexit, which is the greatest constitutional change to the UK for years, that the courts would rule that to be an unlawful prorogation of Parliament?
If I were to answer that question, tempting though it is, particularly...
And he's not going to answer it. Interesting point about who is attending the Houses of Parliament at the moment. There are more Labour MPs in Parliament at the moment than there are Conservatives. Given that the Labour Party conference is currently taking place in Brighton, I find that interesting.
Any barrister who enters into litigation, if it doesn't occur to him that he might lose, is a bit of a nit, isn't he? I mean, really. Of course it occurred to me we might lose. But the reality is it would be ridiculous not to.
Thank you, Mr. Speaker. Will the Attorney General agree with the views of the overwhelming majority of my constituents in Gillingham Arena that the continued delay in delivering on the result of the referendum by the 31st of October is leading to the public having a lack of confidence in our democratic process, and the only way to resolve that is to have that election now and let the public decide?
Let's have an election. Rah, 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 rah.
I completely agree with the honourable gentleman. He's put his finger right on it. It is this continuing artificial prolongation of this dead parliament is undermining people's
I
confidence.
agree. Yes.
I know why they're not doing it, because they know they won't survive. But they've got to have the courage of their convictions and get on with it and put it to the country.
Rachel Maskell.
Still a lot of people standing up.
The Attorney General is trying to exonerate his and his government's determinations by saying that the Supreme Court created new laws, something he said at the dispatch box. Isn't it the role, and wasn't it the action of the Supreme Court to interpret existing law?
That is, of course, one function of what a court's role is, but a court is perfectly entitled to develop the common law. And I don't think there can be any doubt that that's what happened in this case.
Grateful, Mr. Speaker. It's often said that a lawyer who acts for himself has a fool for a client. And it's also worrying if the lawyer is not aware of the costs of the case in continuing with the advice. So could the Attorney General, when he makes a statement about the costs to the taxpayer, include the costs to the House Authority of having to reconvene on 24 hours' notice and the inconvenience to the staff here?
Well, I may say so, Mr. Speaker. May I place on record my endorsement entirely for your expression of gratitude to the staff of the House. They do an extraordinarily great job, and we are deeply grateful to them and grateful for the speed with which they've been able to facilitate the resumption of Parliament.
Angela Smith.
Mr. Speaker, the question of who had sight of the legal advice before the decision was taken remains unanswered. So I ask the Attorney General once again, did the Cabinet have sight of the legal advice, and did the Prime Minister's Chief
He's not going to answer
Advisor,
this.
Dominic Cummings, have sight of the legal advice?
Attorney General.
The Honourable Lady will know that I cannot disclose whether I gave advice or the content of any such advice.
Even I know
it is
that.
Covered by the Law Officers Convention. The question is, was the advice shown? Presumes that there was advice. So it simply contradicts the Law Officers Convention. I wish I could answer a question, but I can't.
Oh, we all do.
Wayne David.
Following yesterday's Supreme Court judgment, the Prime Minister presumably got in touch with Buckingham Palace and
He won't know
to
this.
Her Majesty the Queen.
Why are you asking the Attorney General about something the Prime Minister did?
My question is, did the Attorney General speak to the Prime Minister before the conversation took place?
That's a better question.
I didn't, no.
What fake, stupid shock.
Mr. Speaker, I wonder, would you agree with me that any reasonable Attorney General acting with due care would query, would challenge and perhaps even laugh at any suggestion that 5 weeks of prorogation was necessary in order to prepare for a Queen's speech?
Attorney General.
I think I understood the Honourable Justice, but I don't agree with its premise, no.
Geraint Davis.
The Attorney has accepted the Supreme Court's judgment that the government acted illegally in closing down democracy, but will he accept his duty, his fundamental duty, to uphold the rule of law and democracy and not fan the flames of hatred with the people against the courts, the people against democracy on the road to fascism, as he appears to be doing today by making fun of the Supreme Court and saying they're making things up as they go along?
No, that's not what you're twisting his words.
And all of us should obey the law.
The Honourable Gentleman really needs to listen more closely to
There
what
we
I
go.
say. The Supreme Court was perfectly entitled to reach the view it did. It did so by reasoned decision-making. It was entirely within the scope of its jurisdiction. But there's no question that it developed the common law in doing so. That's all I've said, and
And-
that's what courts often do.
Yeah, that's fine.
Samjima.
Mr. Speaker, it is not fear of the electorate that drives some of us in this House.
Oh, I have to go in
It
a
is our
minute.
determination to do the right thing by our constituents and the country against a government that is determined to deliver Brexit at any price. Mr. Speaker, you've had government ministers saying today that somehow the judgment that has been handed down by the Supreme Court could be disputed by other parties. But they never say which aspects of it they disagree with and on what basis.
The way he's
Could the
framing his
Attorney
question.
General let us know when ministers cast doubt on
No,
this
fine.
judgment, what exactly they disagree with and why they are doing that in public.
Attorney General.
The honourable gentleman asks me about why ministers might contest parts of the judgment. There's nothing wrong with the government or the honourable gentleman or any other member of the public seeking to argue that parts of the judgment were either mistaken or poorly reasoned. Wouldn't necessarily agree with that, but there's no harm in people doing it because that is part of democratic debate. What is wrong, and what I deplore, and what I urge all members of this House not to do, is to impugn the motives of those who make the decisions. Because these are fine judges who reach their decisions impartially on what they think is the best view of the law. And I have no doubt that is what the Supreme Court did in this case. But I'm not, if I may, going to go into all the areas of the judgment that are
Should be reaching the
fragile
next
or
urgent
vulnerable
question very
to
soon.
alternative arguments.
Very,
The
very soon.
arguments of the government were set out in writing.
The Conservative benches are quite rightly, not quite rightly, but they are thinning out. I've just had someone else confirm to me.
Entirely right, but the Supreme Court chose to disagree with it.
Labour, though. Labour wants to stay because they've just had a long journey back into London. Well, not learn. It's not long. It's like an hour and a half.
That this attempted prorogation was about Brexit and nothing else. Isn't the real reason why nobody would testify under oath as to what the government's reasons were, was that even in the government, nobody believed that the Prime Minister's reasons were the truth?
I don't understand the question. That's a
If the Prime Minister
that's a silly
wished
question.
to prevent this House from debating Brexit, he would have prorogued it from the 5th of September to the 14th of October. Because he allowed, even we knew, does it seriously suggest that the government was blind to the possibility that in the first few days of resumption after the 4th of September, that it was not possible that exactly what happened would happen? If we wished to close down all debate and prevent the option of legislation which was ultimately taken by this House with the consent of Mr. Speaker, we could have prorogued it from the 5th, but we didn't. And furthermore, on the 14th of October, there would have been 2.5 more weeks for this House to act. With respect, all this talk about a coup is just nonsense. Inflamed political tripe, invented and inflated so that this gang can justify
He's enjoying this.
clinging to their green benches for another few undeserved weeks. That's what it's all about.
Ian C. Luca.
Mr. Speaker, the authors of this failed political trick, the Prime Minister and Dominic Cummings, have fallen in treating Parliament with contempt. What is truly contemptible and what is cowardly is Dominic Cummings refusing to give evidence to a select committee and being in contempt of Parliament, and now hiding behind the skirts of the Prime Minister, who is supporting an individual who's working for the government in not giving evidence.
These questions are just more accusations than.
Attorney General think that is a respectable position.
Yeah, so who cares about that? Nobody, I assure you, nobody in the country wants to know if the Attorney General thinks it's respectable for one thing or another, hiding behind the Prime Minister.
That attacking people who can't answer for themselves in this House.
They get back Parliament, and I feel like they might be wasting time just a little bit.
Thank you, Mr. Speaker. Will the Attorney General explain why there's a lack of signed witness statements, or is it the case that we all know the civil servants couldn't defend indefensible and they thought the government was at it all along?
But as I've said in the past, Mr. Speaker,
He's made his own statement in his own way.
Witness statements or the internal preparations of the government's case for this Supreme Court.
Alex Norris.
Mr. Speaker, the attorney says that this Parliament doesn't want to do any work, does not wish to legislate. He is wrong. There are very, very many, very important issues that we are desperate to legislate on. None more important than the domestic abuse bill that members across this place and the other place have worked together on for 2 years now, and could easily come before this place, get this into law, and make this and improve the lives of tens of thousands.
Okay, I can consider this to be a good argument. You know, the domestic abuse bill needs looking at, absolutely. But what are you going to do about Parliament?
To schedule tomorrow and next week the important stages of this crucial bill.
I certainly will talk to the Chief Whip about it. If there's a consent on all sides for this House, we might as well do something while we're waiting for them to make up their minds to go for an election.
Patricia Gibbs.
Mr. Speaker, the Queen has been misled, the law has been broken, and Scotland's Supreme Court has ruled that the Prime Minister has been less than honest. Yet there is not a hint of humility from the benches opposite. What sanctions does the Attorney General think the Prime Minister's playing fast and loose with our democratic institutions?
I think this is just a soundbite opportunity.
Attorney General, seriously, coming before us today to tell us that the Prime Minister's position is terrible. Is it not the case that the decent thing for the Prime Minister to do is go?
Well, can I encourage her then to ensure that we vote for the election motion that will be coming before the House shortly? That way she can ensure that what she hopes, she thinks no doubt will take place. But the reality is, no, I don't agree. The Supreme Court found no impropriety on behalf of the government, the Prime Minister, or anybody else.
He couldn't have answered that any other way.
Ian Paisley.
Mr. Speaker, does the Attorney General believe
One left.
that the judgment has left 17.5 million people feeling more disenfranchised than they've ever been? And how should the government and this House repair that damage?
Guessing that's the population of the UK.
I completely agree. The actions of this House are bringing it into discredit. It is abandoning almost all reasonable precedent. The time has come for a general election, and to resist it is immoral, unparliamentary and undemocratic. But that is a decision.
One more.
That is a decision.
Make it a good one.
Opposition has taken. Let us wait and see what the electorate make of it. But I hope that they will understand that what this government is doing is trying to fulfill the mandate of those 17.4 million people.
Is it
and
4 or
we
5
will
million?
never cease until we succeed.
Thank you, Mr. Speaker. It is reassuring to see we are indeed carrying on where we left off. As a senior lawyer himself, will the Attorney General agree with me that any attempts to describe the considered unanimous and unambiguous decision of the Supreme Court as a constitutional coup are nothing more than constitutional bull?
I'm not sure I could adopt that language in a parliamentary way, but this was a legitimate, perfectly reasonable, proper decision of the Supreme Court. We should be proud of our judiciary, proud of its independence in all jurisdictions. I apply that to the inner house, the outer house, the divisional court. Lawyers will disagree on some of these complex and fundamental principles, and that is what has happened here.
Order. And if the point of order relates to the matter of which...
Apparently, Geoffrey Cox has just said that another election motion will come before the House shortly.
At my discretion, take it. Point of order, Emma Hardy.
Thank you, Mr. Speaker. During that question and answer session, the Attorney General made a joke about the phrase, "When did you last stop beating your wife?" Now, part of the reason people are so upset about the prorogation is because the domestic violence bill has fallen, as my honourable friend has just mentioned. Mr. Speaker, can I seek your advice on how maybe the Attorney General can learn to moderate his language and not make jokes?
Sorry, the Geoffrey Cox implied that there'll be another motion coming forward.
Well, it's open to the Attorney to respond if he so wishes, although he's not obliged to do so. Very briefly, the Attorney.
Let me say, if I give an offence, I certainly didn't mean to. It's an old saying at the bar. which is...
Oh, don't do that.
No. Listen.
In the locker room.
Which simply relates to a cross-examination technique of asking a question that presumes the premise. And it's the way in which we were taught.
Ah, I see.
Offense, I apologize.
He was explaining the leading question.
I thank the attorney for responding. This is a matter of extreme sensitivity. And what I would say to the Honourable Lady and more widely to the House is that it is incredibly important that we are sensitive to the wider implications and interpretation
of the things we say.
Of what we say.
Yes.
And the mores of society do change, and sometimes one can find that things that one has quite freely said in the past,
I think we're about to move on.
Can no longer be said without causing offence. But each member must make his or her own judgment. The attorney made his, and the attorney has said what he has said, and I thank him for that. Point of order, Craig McKinley.
Thank you, Mr. Speaker.
No, we're not.
Apologise
It's just
for
point of
not
orders
giving
now.
advance notice for this, but it's advice that I think is very relevant to this debate. We have heard much of how the Supreme Court has extended its remit into the actions of the executive and how that may play out into the future. I wondered if you could give advice, perhaps to your successor, whether the actions and decisions of the Speaker of this House should be similarly subject to judicial review and how that may work into the future.
I'm extraordinarily grateful to the Honourable Gentleman, but as an attempted point of order,
yep.
Frankly, in old-fashioned O-level terms, with which I'm familiar and of which the Honourable Gentleman is probably aware, that would get an unqualified. I'm afraid it wasn't even a good try. I don't bear any ill will to the Honourable Gentleman, but if people are going to have a go at these things, a degree of nuance, subtlety and ingenuity would at least command respect. But there is a grade, and I'm afraid it was way, way, way below the grade. Yes, okay.
Another point of order.
If it's on these matters, but not beyond. Point of order, Hannah Bardell.
Thank you very much, Mr. Speaker, and apologies I did not give you advance notice. During the exchange just before, the Attorney General said this Parliament is a dead Parliament, and he said it repeatedly.
Yes.
And it should no longer sit, it has no moral right to sit on these green benches. Mr. Speaker, can you advise me how we can ensure that the Attorney General makes a statement, retracts those words, because they are beneath him, they are beneath this place. I was sent here
just because they're beneath your standards doesn't mean he has to retract them.
Constituents, and our position should not be undermined by, frankly, such flippant and ridiculous language.
It doesn't mean they have to be retracted. She's made her own point.
There is an important issue here. Is something that causes offence required to be withdrawn? The answer to that, I must say, in all candour to the Honourable Lady, whose sincerity I respect, is no.
Yes.
Lots of things are said that may cause offence or provoke umbrage, and about which there will be dispute, but there was nothing disorderly about what the attorney said. The Honourable Lady has registered her view with considerable force and alacrity, and it will be on the record for her constituents to observe.
Yes.
No impropriety has taken place.
Yes.
And I think we can now proceed to the urgent question. Layla
Here we are.
Thank you, Mr. Speaker. To ask the Secretary of State for Digital Culture, Media and Sport if she will make a statement on payments made by her department to Hacker House and on how her department manages possible conflicts of interest. I thank...
Thank you, Mr. Jeffrey, very much indeed. Minister Matt Warman.
Thank you. Thank you, Mr. Speaker. I thank the Honourable Lady for raising this question today, and I am answering it because it is my portfolio. As honourable members may be aware, my department runs a programme known as the Cyber Security Immediate Impact Fund. The fund is one of a range of programmes, Mr. Speaker, designed to increase the number and diversity of people who are pursuing careers in the cybersecurity profession. And through the fund, we want to support new, creative and innovative projects that are delivered by a range of organisations, including startups and SMEs. We have supported a variety of initiatives awarding grants of between £20,000 and £500,000 since March 2018. Hacker House is one of the businesses that was awarded a £100,000 grant in February 2019 as part of our second funding round. To date, they have been paid some £47,000 for work completed. This is a grant that was awarded by officials from DCMS, by the Department for Education, by Tech UK, and indeed by people from the National Cyber Security Centre. And if she wishes to impugn the motives of those officials, I would invite her to think very carefully before she does so. To date, we have awarded 11 companies to deliver 12 initiatives. Over 400 people, Mr. Speaker, have benefited from support through this fund, and our objective is that even more people will benefit as the businesses with whom we partner further invest in a sector that I know she agrees is vital to the future of our security and our economy. This is part of our mission as a department to identify untapped talent and to help a broader range of individuals who have the capabilities and aptitude to develop their careers in cybersecurity. And I would like to assure the House that all grants are awarded through an open, transparent and competitive process, Mr. Speaker. Each grant is judged on specific assessment criteria and is approved by the panel I referred to earlier, with cross-departmental and industry representation. We are, of course, aware of the claims raised recently by the Sunday Times, and the department is reviewing the decision that was taken, but we monitor all initiatives that have been awarded
reviewed, the process is transparent.
Speaker, we treat any allegations of impropriety with the utmost seriousness. And as soon as
we
I
will
have
do
any
reviews,
further
etc.
information to share on this matter, I will of course update the House at the earliest possible opportunity.
Okay, here comes the questions.
I thank the Minister for his reply. I should make it clear, I care very little about the personal life of the Prime Minister, but I care a lot about how this government manages conflicts of interest and how it spends taxpayers' money. And on that basis, I am concerned that the department appears to have given Hacker House a £100,000 grant in January 2019 as part of the Cyber Skills Immediate Impact Fund, a grant that was open to initiatives based in and that operate from Britain.
So this wasn't when he was Prime Minister Johnson. These allegations are about Johnson.
That Hacker House is not based in the UK. The Sunday Times reports that its owner, Jennifer,
I don't know why this is relevant.
moved back to the USA in June 2018. These grants weren't open for application until November. The registered address of the company is in fact a house in Cheshire, where she used to rent, and the current occupant apparently sends any post addressed to Miss Arcuri back to sender. Mr. Speaker, where is the due diligence? What steps did the department take to ensure that Hacker House was indeed based in and operating?
I mean, she's not answering anything new, asking anything new.
Waive the rule that the grant could not exceed 50% of the company's collective income. And I ask how many of the other 11 companies that we now found have had these grants have had this kind of preferential treatment? And did the Prime Minister...
Okay, she's still...
The backbencher, the Right Honourable Member for Uxbridge...
Go on.
Did he make any representations, official or otherwise, to the department recommending...
Right, she's not asking anything new.
The department says that it will investigate the award of the grant, but will the Minister tell us when will this review conclude?
Right, so he's going to answer about he can't comment, and it will be up for review or looking closely at it, or will respond with a written answer.
Run deeper than just this matter. Mr.
She's trying to dig into him.
That the Minister will not be...
She's a Liberal Democrat, Layla Moran, of Oxford West and Abingdon.
But would he, on behalf of the government and the Prime Minister, ensure that all departments will fully cooperate with the investigation being launched by the London Assembly Oversight?
Of course they will cooperate.
How the Mayor's Office handled conflicts of interest.
This is boring me.
Mr. Speaker, the fact that we are back in the Commons today...
She's asked like 15 questions.
The Prime Minister has been shown to ride roughshod over the laws of this land. It would indeed be disappointing if we were to find that the Prime Minister has form in bending the rules for personal or political gain?
Minister.
Thank you, Mr. Speaker. I want to start by saying that the Prime Minister and his staff have had absolutely no role in the award of this grant. And I suspect I will be saying that a number of times, but it will remain the case. In answer to the other questions that she has raised, the review will be reporting by the end of next month, and I've said that I will update the House where necessary. Of course, we will fully cooperate with any other inquiries. She raises the matter of the match funding, or the 50%. The officials involved in awarding these grants scored this particular application very highly in all other aspects. On that aspect, as they routinely do in a number of other situations, then they decided that the other aspects more than outweighed that particular individual criteria. And on the question of where the company is based, the officials have done the usual due diligence on this company. She herself mentioned the address where it is based. It will, of course, be a part of the review that we are doing, but as I say, this is a company that is based in Britain as far as Companies House is concerned. It is a company with a British phone number. We will review that, but we have no reason to think
He slipped.
We have no reason to think that there is anything untoward.
He implied that the only reason he thinks it's British is because they have a British phone number.
To just finally address the range of issues that she raised at the end of her question, if she wants to raise matters about a grant that was awarded by officials through the proper process, then this is, of course, a completely legitimate forum. If she wants to use this to try and spread tittle-tattle that is much more around politics, then I would say that she should think very carefully before doing that.
Damien Colley.
Thank you, Mr. Speaker. I welcome what the Minister said about the review being conducted in the Department. We'll know that the Secretary of State is due to give evidence to the DCMS Select Committee on the 16th of October. Could I ask whether he or the Secretary of State could write to the Select Committee before then with an update on the terms of reference for the review, any results from the review so far, and also details of other awards?
So just to recap, so yeah, he's going to write. There's a grant process which a friend of Boris Johnson's went through for a company of theirs, and there's a possible conflict of interest, so a review has been launched into it, which is the second urgent question that Parliament is sitting for at the moment after they reconvened from the false prorogation which has since been withdrawn.
And thank the member for Oxford Western.
We might stop this now. We might go away from Parliament and in fact from this live stream, because the meat of the matter has been done for now. The next thing to happen will be that Boris Johnson will have a statement. We're thinking about 5-6 p.m. now. And we don't know quite what that will contain. What else is happening? Let me just show you this. It might make it easier. So we're on the Hacker House urgent question at the moment. There may be a third urgent question decided by the Speaker of the House if it comes in, but I don't think that will happen. And we've got 5 statements. One from the Secretary of Transport about Thomas Cook. We have a statement from Michael Gove about the leaked documents of Operation Yellowhammer, Dominic Raab, Foreign Secretary on Iran, and then Boris Johnson, Prime Minister, an update to Parliament, which will be the headline grabber. And then the Leader of the House is going to make a business statement about what's going to be happening in the House of Commons to come. Oh, I see Jeremy Corbyn, by the way, is now sitting inside the House. I'll just bring this up. You can't see him there. There he is, on the right-hand side there. Let's just listen to what he's saying.
Prime Minister, the issue of whether he has represented the interests of this company or other companies.
Okay, they're still talking about the conflict of interest. But Yeah, so the meet is going to happen, we're thinking 5-6 p.m, the statement from Boris Johnson. We don't know what House of Commons is going to be doing tomorrow or every other day, and to be honest, before it got prorogued, nobody really cared. But now people are going to care, I suppose. Okay, that's it for me. Cheerio, bye, 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 bye.